Gavin Newsom's California government recently approved a terrifying speech code that, starting in January, could punish doctors who freely talk to their patients. Well, some of those targeted doctors aren't taking it, and they just filed suit. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and concerned Americans likely recall the September 1st CNS bombshell on the California Assembly taking its licensing absurdity to a new level. In passing AB 2098, the Golden State government established a first-in-the-nation precedent, combining the fascist licensing paradigm, i.e., you can't work without our permission, with the authoritarianism of speech controls, allowing the Medical Board of California to pull the license, i.e., the livelihood, to pull the license permission slips of doctors who, as they say, disseminate misinformation or disinformation related to COVID-19, which combines the malevolence of aggressive shutdown threats with the conceit of the state somehow possessing perfect knowledge about what is misinformation and disinformation. Based on the abysmal record shown by California Governor Gavin Newsom when it came to the value of masking, rules, by the way, that he repeatedly broke himself, based on Newsom's walking in lockstep with other states and federal government mandated lockdowns of businesses, and based on the terrible record of federal officials when it came to everything from the efficacy of their first flood of tax-funded mRNA jabs and then boosters to their manipulation of COVID numbers, the numbers themselves that were unreliable, it's pretty easy to note the emptiness of any government claim to omniscience. And some California doctors are fighting back. Jacob Sullum reports for Reason that the New Civil Liberties Alliance, NCLA, is working with numerous doctors in the state of California to bring suit against Newsom and his political pals who would strip them of their ability to legally work should the state deem their speech wrong. Quote, the NCLA, which is representing 5 California physicians who object to the new law, argues that it violates the First Amendment by punishing doctors based on the views they express and the 14th Amendment's guarantee of due process by imposing an unconstitutionally vague standard of acceptable speech. The statute is set to go into effect on January 1st, 2023, and Sullum explains that the NCLA has put its finger on just how dangerous this law is going to be. Quote, the law imposes a quintessential viewpoint-based restriction because it burdens speech determined by the board to diverge from the contemporary scientific consensus, the NCLA says. In safeguarding Americans' rights to free speech and expression, the First Amendment applies not only to expression of majority opinions, but to minority views as well. Indeed, it is minority views that need protection from government censorship, as this law shows. Nor is there an exception to the prohibition on viewpoint-based discrimination simply because the law applies only to a regulated profession. In short, AB 2098 infringes plaintiffs' First Amendment rights because it impedes their ability to communicate with their patients in the course of treatment. And adds Sullum, quote, even if a doctor were keen to avoid deviation from the scientific consensus regarding COVID-19, he would have a hard time figuring out what that means. The term contemporary scientific consensus is undefined in the law and undefinable as a matter of logic, the NCLA says, and many viewers might not be aware that this is actually a wider problem than that which is seen in California with AB 2098. For nearly 3 decades, federal-level personal injury lawsuits have been saddled by a practice adopted by judges called the Gov't hearing. This changed the standards by which expert witnesses could be called by defendants or plaintiffs in personal injury suits. Prior to the 1994 Supreme Court case Gov't v. Merrill Dow Pharmaceuticals, juries heard testimony of those labeled expert witnesses as long as the witness had some kind of credential, such as a degree in the particular field in question, or some long-standing expertise. Now, this standard still was arbitrarily created by the government, but it allowed for much wider acceptance of differing scientific views, letting juries judge the information for themselves. But Gov't saw the Supreme Court establish criteria that included the court deciding if the proposed witnesses' views were within the scientific consensus. There's that term. So not only do judges have to have knowledge of the United States and state constitutions, of common law, of statutes and judicial temperament, they also must now know the scientific consensus for every case that might involve science that is presented to them. What would they have done if Galileo was tried about this time for heresy, even though Galileo was right? His views, of course, were not in the scientific consensus at the time. Ad Sullum, quote, "When it comes to COVID-19 treatment, conventional wisdom likewise has evolved in light of emerging evidence. At the beginning of the pandemic, the NCLA notes the standard of care for treatment of patients with severe COVID-19 was intubation. One of the plaintiffs in the NCLA's lawsuit, Ram Durasetti, an emergency room physician in Burlingame, resisted invasive intubation while the consensus was evolving. Then the consensus changed, and his view became the prevailing one." The heart of this issue is not merely the California government claim to omniscience, and not just the idea that any state can determine what is in the scientific consensus. Those are bad enough. But it's important for Americans to see the evil in the political conceit of the government claiming to be able to tell people whether they can get a license merely to offer someone services or products. Certainly, this instance sees California claiming to know the science and use that as a reason for pulling licenses. But the reasons politicians might pull out of their evil magic hat of license tricks can be infinite. Some of the earliest licensing laws were pushed in the Jim Crow South as ways to keep newly freed slaves stuck on their plantations rather than let them leave to work at better jobs. Fundamentally, licensing is an immoral abrogation of free association. Regardless of current rationales offered by California or any so-called justification that politicians might present, the very act of adopting unto oneself the power to tell other people whether they can or can't engage in peaceful commerce is an act of immoral aggression. In this California case, we can see one example of its pernicious effects. This, clearly, is part of the much larger government and big corporate pals versus the people and free speech battle that we've seen explode since March of 2020. But it's incumbent on us to recognize the even larger scope of the problem and oppose the immoral imposition of license laws themselves, regardless of the various rules the politicians arbitrarily include in those laws. Thank you so much for watching, everybody. Some great history to learn here, even as we look at this terrible frustration and this awful, very frightening law that is going to start up for execution on January 1st, 2023 in California. All the best to all those people who might be fighting against this and everyone who fights for freedom of association and free speech and free markets. For freedom. What's so tough about it? We'll see you on Twitter at the MRC-TV Twitter handle. We'll see you on Facebook in the MRC-TV Facebook page. We'll see you in Parler, yay Parler. We'll see you on TikTok and Instagram. And of course, please visit MRCTV.org, the Media Research Center, in its 35th year of operation. mrctv.org. If you want to find me, I'm on Gab at Gardner Goldsmith, and I'm on Twitter at Gard Goldsmith. And of course, the videos, Rumble doesn't censor us. Please sign up over there and share the videos from Rumble. And of course, YouTube, we're still there. We'll see you in the comments section. Thanks so much for watching. For MRC TV, I'm Gardner Goldsmith.